Welcome to Rapid Fire Wednesdays, Q&A for corporate immigration professionals. I'm Kimberley Robidoux, partner in our San Diego office, and I'm joined as always by Miki Matrician, co-managing partner of our Boston office. How are you doing today, Miki?
Well, how are you, Kim?
I'm doing great. I'm still enjoying the East Coast, so it's really nice over here.
I think I can hear the cicada in the background.
They're active right now. They want to participate in Rapid Fire Wednesday. They have something to say too. But we are going to discuss a few updates from the past week. It's going to be a mixture of court decisions and policy on notices to appear, which are related to non immigrant petitions, and then the new policy related to naturalization applications. So, Miki, let's get started with some good news about the ICE raids in Los Angeles. So, what is the latest with the litigation in California?
Yeah, so I'll start off with a little bit of background first. So, in early June, Immigration and Customs Enforcement sent heavily armed agents, and many of them in masks and military style uniforms, to really aggressively detain immigrants. And, some US citizens ended up being detained as well. In many cases, ICE used wartime equipment as they detained immigrants at Home Depot and car washes and Latino markets across Los Angeles. And the administration during these ICE actions said that it would bring similar actions to cities across the US, especially in the blue states. And so a coalition of civil rights and immigrant rights and local government agencies sued the federal government. And the U.S. District Judge Frimpong in the Central District of California issued a temporary restraining order in July, saying that there was a mountain of evidence that the federal government's aggressive enforcement tactics were likely a violation of the individual's Fourth Amendment rights against unreasonable searches and seizures. The Ninth Circuit Court of Appeals then denied the federal government's appeal of the temporary restraining order, and they've now filed an emergency appeal with the Supreme Court, saying that the order poses a significant barrier to enforcing federal immigration laws. And so the request for stay is filed on the Supreme Court's emergency docket. So that means that oral arguments are not likely. The ICE raids appear to have been primarily driven by their goal of 3,000 or more immigrant arrests per day, which an official has said is necessary to carry out Trump's mass deportation agenda. And in the meantime, although the restraining order didn't entirely stop immigration enforcement in LA, arrests and the roving patrols by ICE and CBP have been curtailed.
Yeah, so that does provide for some relief in Los Angeles at this time, and I'm anxious to see, how this plays out in the Supreme Court, especially since I'm located in Southern California, and we'll see how that progresses. So previously on Rapid Fire Wednesday, we talked about the executive order on birthright citizenship and provided an update. So now what's happened is on July 25th, 2025, the federal government had published implementation plans and provided new details about how it would implement the executive order if it were allowed by the courts in the future. So the government did recognize that the birthright citizenship executive order had been blocked by multiple courts. And on August 7th, the judge in the Casa versus Trump litigation granted the plaintiff's motion for class certification, as well as the motion for preliminary injunction. So this new injunction protects all babies born in the US, and it replaces the previous injunction that was limited to the Asylum Seeker Advocacy Project and CASA members only. So that's a little bit of good news on birthright citizenship that we have an injunction and a class action in place right now. And so let's talk about the policy shift at USCIS that has resulted in an increase in the issuance of notices to appear, or what we refer to as NTAs. So, Miki, can you please explain, what NTAs are and how the issuance of these NTAs is impacting foreign nationals when applying for certain non-immigrant classifications such as H-1B status?
Yeah, so an NTA is the notice to appear. It's basically the charging document that is issued by the Department of Homeland Security to start removal proceedings in immigration court. And it really requires that the individual appear before an immigration judge. And so once an NTA has been issued, the case becomes part of the removal system, and that whole system is managed by the Executive Office for Immigration Review, which is under the Department of Homeland Security. And the case needs to be resolved in immigration court. And in the normal course of things, it could take years due to the huge backlog of cases in immigration court. However, we've recently been hearing from colleagues in the immigration bar that some of these hearings have been taking place just within a few days of the issuance of NTAs. And it does impact global mobility and HR professionals. And why is that? It's because there's been recent reports of a trend that's related to removal proceedings being initiated against H-1B workers following termination of their employment. So, this is a significant new development that we had not really seen before. Some H-1B workers have received NTAs following the withdrawal of the H-1B petition by their former employer. And it seems to be occurring even when the foreign national is here in the United States lawfully. So, for example, the foreign national may be in the US for up to 60 days when they leave H-1B employment. So the 60-day grace period is no longer than the expiration of their I-94 document or 60 days, whichever is earlier. So this is a discretionary 60-day grace period following the termination of employment. And the idea is that the foreign national can leave the United States during those 60 days or file a change of status application or have a new change of employer H-1B petition filed on their behalf. And the 60-day grace period applies to several visa categories, including H-1B, TN, O-1, L-1. But most of the recent cases that we're hearing about with regard to the NTAs have involved H-1B workers. So, what it sounds like is the NTAs are appearing to be issued soon after the H-1 petition is withdrawn by the former employer. And so, it's really important to know that during this grace period, the worker is not in lawful status, but they can remain as being under a period of authorized stay while they're waiting for approval of their new petition or application. And under longstanding USCIS policy, people in that situation aren't typically placed into removal proceedings unless they otherwise, warrant removal proceedings due to criminal convictions or visa status violations. So, global mobility and HR professionals may want to factor this new trend into their policies related to change of employer petitions and the timing of filing the H-1B withdrawal notification when an H-1B's employee's employment has been terminated.
Yeah, so that's a lot to unpack and some serious issues for global mobility and HR professionals to consider with their immigration policies, especially as individuals are changing employers. So we're going to move on from the NTAs, and our last update takes us essentially to the last process in an immigrant's journey in the United States, which is naturalization. And on August 15th, USCIS issued new guidance that significantly increases officers' discretion to deny naturalization applications. So, USCIS officers are no longer limited to statutory bars such as criminal convictions or false testimony. When reviewing good moral character, they can now deny naturalization applications based on what appears to be vague, subjective standards of good moral character. So applicants are expected to not only avoid misconduct, but also to demonstrate affirmative positive qualities such as community involvement, compliance with tax laws, as well as family responsibilities. So even lawful behaviors like extended unemployment or reliance on public assistance may now weigh against approval of a naturalization application. So, for global mobility and HR professionals that have programs to assist employees with obtaining their naturalization status, either for ease of business travel or to work on certain projects, this shift means naturalization cases may require more documentation, longer adjudications, and early engagement of legal counsel to discuss pros and cons, as well as what evidence or information might need to be included. And then employees will need to be proactive in highlighting their positive attributes and be prepared to explain any conduct that could be viewed unfavorably. So, with that, I guess that wraps up this week's Rapid Fire Wednesday. We'll continue monitoring legislative, regulatory, and court developments, as well as agency guidance, and provide updates in future episodes as we hear of them. As always, for all the latest updates to the immigration landscape, please follow WR Immigration on LinkedIn, as well as Miki and my personal profiles for breaking updates and insights. And we also transcribe each and every episode and share it through our weekly newsletter, which you can subscribe to. The link to subscribe can be found in the video description. So thank you for joining us, and we'll see you next time. Great to see you again, Mickey.
Thanks, Kim. Good to see you too.